Good morning, Mr. Daniel. Good morning, Miss M. Can
Good
both of you hear
morning.
me okay?
Yes, we can.
All right. Can the clerk call the first case?
325-0183, Real Estate Naperville II, LLC, Applee Cross Appellant versus E&S Management Group, doing business as Waterside Center Series, Appellant Cross Applee.
Miss M, if you're ready to proceed.
Uh,
All right. Good morning, Your Honors. May it please the court. My name is Angela Im. I'm the attorney for the appellant E&S Management Group. While there are a number of issues before this court, the controlling issues are simple and straightforward. The central facts are, when Rent2 constructed its building, rather than installing its own equipment, Rent2 latched onto certain of E&S's equipment. Not only did Rent2 use E&S's equipment, Rent2 consumed E&S's water, electricity.
Counsel, you're saying at the time that these were done, you owned the building or your client owned the building?
No, I am not saying that, Your Honor. I'm saying that E&S owns that equipment today. And so I'm calling it the E&S equipment, but at the time it was owned by Real Estate Naperville 1.
And they were cooperative in whatever was done at that time, correct?
The record doesn't show that, Your Honor, because at the time that it was done, a gentleman named Philip Marone was the principal of Real Estate Naperville 1, what we're calling REN 1, and he was also the principal of REN 2. But REN 1 and REN 2 are completely separate entities, and there's no and they have.
But he was cooperating with himself. I mean, it was cooperative.
Well, again, I'm not sure that the record shows that because when he testified at summary judgment, he said he didn't know that the fire suppression systems were connected. He didn't know that the alarm control was connected. So there's no indication that when he was talking to his developer.
Thank you.
Okay. The central facts are when Rent2 constructed its building, rather than installing its building, Rent2 latched onto certain of E&S's equipment. Not only did Rent2 use E&S's equipment, Rent2 consumed E&S's water, electricity, and alarm monitoring services, and Rent2 also uses a pylon sign located entirely on E&S's property. None of those facts are in dispute. This case is about Rent2's attempt to put a legal sheen over what is really trespass and theft. Rent2 wants a pass to free ride on E&S's equipment, a pass for essentially stealing E&S's water, electricity, and alarm monitoring services, a pass to free ride on E&S's expenses of maintaining the large parking lot where the pylon sign is installed. The circuit court erred in granting Rent2 its free ride pass by finding rights under the Declaration of Reciprocal Easements that simply don't exist. The declaration grants an easement for Rent2 to install and use its own equipment and pipes for utility services for its property. It does not, as the circuit court ruled, grant Rent2 the right to use E&S's equipment or to take and consume E&S's utilities. The plain language of the declaration and well-established legal precedent simply do not support the circuit court's decision. Moreover, Rent2's connection to E&S's fire suppression system was illegal. Overwhelming unrebutted evidence establishes that Rent2 violated multiple Naperville code by failing to install its own fire suppression equipment, fire alarm control panel, and fire water line. The E&S building was constructed first, and more than a year later, Rent2 constructed its building, connecting the two buildings through a wall constructed on the lot line. Rent2 thereby created a party wall between the two buildings. Naperville code required Run-2 to construct the party wall as a firewall and to create the Run-2 building as a separate building. Run-2 argued at summary judgment that its building is an addition to ENS's building, but that would itself would be a breach of the building code and a breach of the declaration. In any case, any portion of a single building separated by a firewall is considered under Naperville code to be a separate building. Naperville code prohibits a single water line from serving two buildings. Likewise, the DuPage County Code prohibits a single water line from serving two properties under separate ownership. Thus, Run-2 was prohibited from connecting its building to the water line in ENS's building, and Run-2 nevertheless did that.
Council, so they were taking your, I understand that the fire suppression lines went from one to the other, but I assume that that's a closed system. I don't know that one way or another, but didn't they have their own separate water line, or they were using your water completely?
They were using our water completely. And in fact, if you read the complaint, their complaint says that that's the basis for filing a claim under the declaration, that they have the right. It's the water is the utility that is giving them the right to use the equipment. And they connected the sprinkler pipe to ENS's sprinkler pipe. So the water ran from ENS's water main through the hydraulic riser system, through the ENS's sprinkler pipes into their sprinkler pipe. So it was connected by this big 3-inch main pipe connecting our sprinkler system to their sprinkler system. That's how they got connected to the hydraulic riser system, and that's where.
No, I understand that your fire suppression system was the brains and the heart of the fire suppression for theirs, but you're saying your water main was also going directly to them?
Yes,
all right. Those were not the facts I read. Go ahead though with your arguments, please.
Okay. Yes. They were using the water from ENS's water main, and the water flows through ENS's building to Run-2's building. And that, if you look, Judge Heddle, the disconnection was the removal of the water pipe that made the water flow from our building to their building. So it's the disconnection of the water main.
I think our definition of main might be different, but I don't want to get caught up on this.
Okay. Naperville's Fire Marshal, Scott Scheller, testified that if it's a separate lot, addition on a separate lot, it would be treated as a separate building under Naperville's building code. And under Naperville's code, separate lots require separate fire prevention systems. Fire Marshal Scheller's testimony is unrebutted, and the parties stipulated as to the governing Naperville ordinances. That's the uncontroverted evidence in the record. And the conclusions to be drawn are: the circuit court erred in denying summary judgment on the parties' cross claims for breach of contract. Whether the Run-2 building is a separate building under Naperville's building code is a question of law, not fact. And Fire Marshal Scheller's testimony on this point is uncontradicted and must be accepted as true. In its final judgment, the circuit court erred in finding ENS breached the declaration by disconnecting Run-2 from ENS's fire suppression equipment, even though uncontradicted evidence showed that Run-2's connections were illegal. In so ruling, the circuit court stated that the legality of Run-2's connection was irrelevant, and we respectfully disagree with that. Contracts for illegal acts are just never enforceable. In ruling on ENS's counterclaim, the circuit court also erred when it said that ENS failed to offer any evidence to support its contract allegations. We believe that that's demonstrably wrong. Among other allegations, we allege in paragraph 40 of our counterclaim that Run-2 violated municipal code by failing to install a fire suppression system in breach of the declaration. And Fire Marshal Scheller's unrebutted testimony and the stipulated municipal ordinances establish these facts and are ample evidence of Run-2's breach.
Zim, can you talk about the concept of the easement, an easement for the use of the water under VA2, section VA2?
Yes, Justice Davenport. I was just about to go there.
Oh, okay.
Okay, so So Run 2 argues that it has an easement under Section 5A2 of the Declaration to use ENS's equipment and to consume ENS's utilities. We say that again, Judge Heddle, because they were using ENS's water and ENS's utilities. That's not in dispute. In fact, at trial, that the council stipulated to that. We believe that there's no plausible interpretation of Section 5A2 as granting Run 2 the right to use our equipment or to consume the utilities. Section 5A2 grants the parties an easement for the construction, installation, or service of utilities, subject to Section 5B. Nothing in that granting language allows Run 2 to use ENS's equipment or siphon off ENS's utilities. The circuit court erred by finding Run 2's connections to be within the scope of for the services of utilities language. And we believe that interpretation doesn't make sense because Run 2 is using ENS's equipment and utilities, not servicing its own equipment or utilities. And then if you go further, if, as the circuit court held, if ENS's equipment is for the supply of Run 2's utilities, then ENS's equipment are systems for the transmission of utilities, which the declaration defines as a utility line. And under Section 5B2, Run 2 is required to install at its sole cost and expense all utility lines serving its parcel as a condition to gaining an easement under Section 5A2. So if Run 2 does not satisfy that condition, it has no easement under Section 5A2. The Run 2, it's undisputed, Run 2 did not install ENS's fire suppression equipment. Run 2 did not install ENS's transformer, which ENS's predecessor paid $40,000 to install. Run 2 did not install the fire alarm control panel. Run 2 did not install the electric vault, which is the foundation for the transformer. Run 2 did not install ENS's gas meter bank, which Run 2 uses. And again, those facts are undisputed. The circuit court erred by finding that despite these conditions of Section 5B2, the circuit court nonetheless said that Run 2 satisfied the Section 5B2 condition by installing the pipes and wiring to connect Run 2's building to ENS's equipment. So just by simply installing the connections, which they said were utility lines, that satisfied the condition to use ENS's equipment. We believe that flies in the face of Illinois law, that easements are to be narrowly construed. And it's contrary to the plain language of the declaration, requiring Run 2 to install all utility lines serving its parcel, not merely just enough piping and wiring to freeload off ENS's utility lines.
Sim, again, you're referring, are you suggesting that they're using your power completely? That they're running all of their utilities off of your back?
They are not running all of their utilities off of ENS, but they are using some. That is stipulated too.
All right, just all they're using is what goes to the fire suppression system. Is that correct?
They are their fire alarm strobe lights, the alarm
fire suppression system. Is it just for the fire suppression system?
Well, the alarm control, yes. I mean, it's all part of the fire prevention system.
You keep intimating that it is more than that, along with the fact that somehow they came to you after you were there first. But let me talk about the panel itself. So what happened in the past before your clients bought it was their meters run to what your predecessor put in the ground, pulled up to the side of the building. They put their meters right next to those and ran from that. Is that what the situation is? Well,
what they did was they connected the meters are just the what it suggests, the measuring device, right? For conduit for the electricity. But the electricity, the source of the electricity comes from the transformer, which itself is also then connected to the Naperville electric grid. So what we're saying is that that the transformer and the electric vault that it sits on are facilities and systems for the transmission of utilities, and they didn't install that. And that's what they did. They connected their electric meters to the transformer and ENS's electric vault. And then they install their meters on the building next to our meters.
And you're arguing that that's why their easement fails, because they didn't do the first part.
That's correct, Judge
Okay.
Settle, that they didn't install the transformer or the electric vault.
Thank you.
And just because I think that I wanted to address this point. The reason that I keep going back to the fact that they are consuming our utilities is because the circuit court found that Run 2, it's stipulated to. I mean, there's no disagreement in that Run 2 was using ENS's water. In fact, as I said, in their complaint, they say that that's the water source and we're trying to disconnect them from their water source. So they're using our water and they're using the electricity from our control panel for their alarm device. So they're consuming those utilities. The reason that I keep broadening that application beyond those two is because this declaration grants perpetual rights and it runs with the land. So the agreement is not we're not talking about a mere contract between two parties, but a declaration that applies across the board that runs with the land. And the circuit court placed no limiting conditions on their interpretation. So there's no limiting principles. So if there's an easement to use the water and electricity from the fire suppression system, then you can extrapolate and say that you can use it for other equipment and other utilities.
Ms. M., your time is up, but you will have 5 minutes in rebuttal after Mr. Daniels has an opportunity to proceed. Mr.
Thank you.
Daniels, if you're ready.
Good morning, everyone. Thank you for the time. I'm Mark Daniel. With me is co-counsel, I think he's on the alternate channel, Mark Wetterquist, who's also a friend, and he's been dealing with this for quite some time. I want to thank the panel, the clerk and staff for their work on this. May it please the court. Ren 2's appeal really relates to two narrow issues. The first is the existence of a sign easement, and the second relates to legal fees recoverable under the declaration. I'd like to address a few things that ENS raised during argument. Justice Heddle, I think you hit the nail on the head. We are not guilty of theft. ENS could never establish the first element of trespass, which is an unpermitted access or entry into the property of another. That could never be established at trial. What happened here goes back to 2000. In 2000, Menard Inc. acquired a large tract of land in Naperville. They divided the property into two lots first. That is Exhibit P12 and D10. In 2003, they recorded something. 2003 was a pretty big year. Not only did you have the second re-subdivision to create a shopping center, Menards is lot one. You had a plan development that was approved. A plan development involves the approval of a plat. And that is exhibits D11 and P13, plaintiff's exhibit 13. With regard to exhibit P13, we have in the appendix at pages 164 to 167 some zoomed in portions of the plat that was approved and recorded in the recorder's office of DuPage County. Also in 2003, there was a grant of easements that was executed. And these are public utility easements, not easements that run between the owners. These are grants for NICOR, for drainage, for the city of Naperville when it comes to access and to any other utilities that come into play. Menards still owned all of it. Menards planned the subdivision. They decided how they wanted it to be built. They maintained control over construction. They approved construction. They approved sign locations. They approved transformer and utility locations. They were the covenantor or the declarant under the declaration that Justice Davenport asked about Section 5A on. That's Menards. Everyone after 2003 is a subsequent purchaser. And when they bought that land subject to the plats and the declaration, plain and simple. E&S comes along in 2017, 14 years later, and 2 or 3 years after that files this act or has to defend this action because they want to disconnect our fire suppression and alarm system. And I want to address those with some clarity here. The fire suppression system is a system whereby water is fed from the city's water main through what we call a fire main. It goes into a riser, and that water is parked in a system of pipes above the retail space in the shopping center.
Does the city charge for that water, Mr. Daniel?
The city does charge for that water, but it's not flowing water. It only flows when you have to test it and release a little bit to make sure that the water does flow and there's not a blockage to some part of the system. So it's a fixed system.
Well, it's not a closed system. It might be let's not get into definitions we're not good at.
Right.
The water does come in and you do pay for the water in some de minimis fashion, according to you.
I do not allege that we pay for it.
No, I meant someone pays for it.
Someone pays for it, yes. So the city does charge for that. With respect to the fire alarm control panel, the fire alarm control panel is wired to a few locations in the building. First, the fire alarm control panel senses whether or not there's an imbalance in the water system. So if a part of the system has a sprinkler go off, the fire alarm is going to go off because the water's moving. It detects that. It also senses for smoke and heat at the different places throughout the shopping center. That system requires electricity for the monitoring purposes. All right. Now, those are just two of the shared obligations. The one thing that E&S and REN 2 agree on, fortunately today, is that those are utilities. They are shared improvements that operate to provide an important service to Lot 2 and Lot 3. And Ms. M testified at trial. This was somewhat difficult because Ms. M was counsel and a witness at trial as the owner, but she testified they were utilities. They were utilities serving both units. So when E&S refers to, I believe it was our riser, the riser may be on their property, but we've got a shared interest in that riser. We have a shared interest in the pipes, no different than they have their shared interest in the drive aisle that crosses our property, the loading zone, the handicapped accessible routes that cross our property, the parking lot lighting, the wall lighting.
Mr. Daniel, I think we'd all agree that the pipes that travel underground or the electrical connections that travel underground, nobody's arguing about that. Ms. M is arguing that you should have put in your own vault, your own space where all of that stuff would come out of the ground so it could go to the back of your building, not the back of her building. Obviously, this happened before she owned the building, but what is your response to that?
Article 5A of the declaration clearly provides easements for utilities. That would include the metering system for electricity and gas. That would include the pipe that draws it into the building.
Well,
and it includes the.
Wouldn't it be just the utilities that are underground that it's providing easements for, or you're saying it's above ground easements also?
It's everywhere and any place, underground, above ground, through walls. There's no limit. This is a shopping center, and you can't have limits because you get into situations like this. And this is exactly why Menard had the declaration. You have someone coming along 17 years after construction to dispute these issues. That's why the easement in Article 5 of the declaration is broad. That's why Judge Hayes properly did not put limits or guardrails on the easement in addition to what Menards had already planned for. That's not for the court to do at bench trial. And in this instance, Article 5 is very clear. It grants easements for those utilities. Now, the transformer is it's a device that is within a vault. And Ms. Im says we needed to create our own vault. That's not true. And the judge found that based on the testimony of witnesses at trial, that was not the case. Under the circumstances, you had Tom Sinek, you had Naperville electrical staff, utility staff, because it's a Naperville utility, they all testified that this was properly done. The other thing that I'll note is when it comes to properly done, coming along in 2017, after you receive a special warranty deed that notes all these items in the title history, every plat, every ordinance could have been traced through that. Ms. Zim, when she drove by the property, she testified that she saw the sign on Lot 2 that had sign panels for Lot 3. None of this is a surprise to her. The special warranty deed itself references these things. So that creates one sense of permission and authorization and awareness. The other issue is that when staff applies the fire code and the building code, okay, Ms. M, beginning in 2018 says, well, your fire system's illegal. I'm sorry, we have had occupancy for 12 years across the center. We had building permits. We had fire and life safety permits for construction, all separate permits that were all applied according to the ordinances in effect at the time of construction. At no time was there ever a code violation noticed to REN 2. Not once during the course of our operation of the center. The only time those code violations hit was when Ms. M knew that when she disconnected our suppression system and our alarm system, that we would have violations issued. Because we
Mr.
didn't
Daniel,
have,
she went to court to ask for permission to do that, though, correct?
she tried to get the court's blessing. She did not. She did it on her own.
Well,
There's
you
no
asked
order.
for a TRO,
We did.
and it was denied.
It was denied on issues that did not relate to the substance. That was not decided during the TRO. When Judge Fullerton addressed the TRO, he was addressing other elements under the 4 standards. What is our remedy? He said, it sounds like you're going to have a damages remedy if she does it. First of all, so that
But he didn't stop her. You spoke directly to Judge Fullerton and asked him to prevent her from doing what she eventually did, correct?
we asked Judge Fullerton to stop her from acting, yes.
Okay. And he did not.
And he did not. He did not. But that is a temporary restraining order request, and she went and did it on her own at her own risk. And Judge Fullerton, in his ruling, if you were to review the transcript from that hearing, Judge Fullerton warned her. Judge Fullerton was very careful and said, this is a TRO. You obviously have things to do. I'm available to talk about resolution, but proceed at your own risk. This matter's getting scheduled for discovery and everything else, and we're still at issue. So when she acted, we ended up in a position where we get 4 citations from the city of Naperville. And we had to respond to those. We incurred between $60,000 and $70,000 in damages, I believe. The judge properly awarded those at trial. And again, this is a bench trial. All right, Ms. M, during her argument for ENS, addressed a lot of matters that this court sitting in review, when it comes to fact, Judge Hayes sitting at bench trial, observing the witnesses, including Ms. M and including the Naperville witnesses, makes the conclusions of fact. And there's nothing here that is clearly erroneous based on the record. From occupancy and permitting all the way through disconnection, it's very clear that we benefited from those utilities. On the sign easement, the facts there are uncontested. There is a sign benefiting Lot 3, REN 2's property. that is situated on E&S's property. The sign easement arises in Exhibit D12, I'm sorry, it's Exhibit D11 and P13. That's the final PUD plat for Waterside Center from 2003. Throughout all the platting, rectangles indicate signs. In the initial PUD for Menards, a rectangle is called out with Menards sign. In the 2003 Waterside Center PUD plat, where they created lots 2 and 3, with lot 3, our lot, having a bank and a drive-through, the signs across the front of the property are indicated with rectangles. In fact, if we're addressing summary judgment, and I don't think you should, that issue merged with trial, and I can address that if you have other questions on it. We said it in our brief. But one of the affidavits submitted in support of summary judgment was an affidavit that attached a site plan from the lease between the Lot 2 owner and Michael's, the craft store that they have as their largest tenant. And that's at C7611 in volume 9 of the record. We actually copy and paste it into page 68 of our brief. This is a lease that E&S has with Michael's by way of their purchase. There's a circle around the sign on Lot 2 that says Lot 3 sign for Lot 3 building pad. So even they have to acknowledge that that sign is for Lot 3, even though it's on Lot 2. It's connected to the Lot 3 building. That is uncontested. There's a line drawn in the plat that we've highlighted. Again, there are portions of the brief that we give you the history on. It's very important to keep in mind the sections of the brief at pages 7 to 14. It gives you the whole history. But pages 164 to 167 of the appendix will zoom in on these plats from the record, because you can't look at the plat and easily see some of this language. But there's a
Counsel,
line.
your time is up. You're going to have 5 minutes in rebuttal here, but are there any questions?
No, not at this time.
Thank you.
Justice
No.
Anderson?
No.
Mr. Daniel, I'm just struggling to look. So P167, excuse me, A167, is that what you're referring to?
Yeah, A167.
I just don't have the skills to make it big enough for me to see what you're asking for. But
This is the circle, correct, on the sign?
the circle on the sign is on page 68 of our brief.
Okay. All right. Why don't you look for that? I just want your best illustration of what you were describing. But I'm going to turn it back over to Ms. M right now, and you can tell us when you come back for your final 5 minutes. Ms. M.
Okay, just to start out off with, trespass is not merely just the entry. Once title passes, says unless there is an easement, if they're there under a license, since Phil Marone gave them permission, even if he did, there's no evidence of it, but even if he did, acting on behalf of Run 1, gave them permission, again, there's no evidence of that it is at best a license, and that license terminates upon the transfer of title. And if you stay on the property after your license terminates, that's trespass. Trespass isn't just the mere entry. It's the invasion of the owner's exclusive right to use that property. And so you have to have an easement. And they're saying that they have an easement under Section 582. And we disagree. They refer to the fire suppression system and the fire alarm control panel and the water and the electricity flowing from them as, quote, a shared utility. It's a shared utility because they attached to E&S's building. It's not a shared utility because we commonly own it, that there's an easement where there's an agreement where we agree to give them access to it. It's shared because the ENS's predecessor constructed the building first. They installed the fire suppression system. They installed the sprinkler system, the fire alarm control panel, and a year plus later, Rentu acquired Lot 3. Their sprinkler permit application shows connecting to the quote existing fire suppression system, the quote existing hydraulic riser system. So when Mr. Daniels refers to it as a shared system, when the circuit court refers to it as a shared system, again, it's only shared because they connected to it. Our argument is they had no right to connect to it. I mean, that's precisely our point. And, on that, I think that the best way to think about the Section 5A2 easement is that it's like ingress and egress.
Ms. Sim, they had no right. They were given permission. You can't argue license and then not argue license. Were they given permission?
What I'm saying is that at best, the record doesn't show that at any time Mr. Marone acted on behalf of Ren 1 to give them permission. But what I'm saying is that even if they did, it would be a license. There's no contract. It's under the statute of frauds.
I understand that argument, but you were starting to argue that they somehow adversely did this.
No, I'm not stating that. All I'm saying is that Mr. Daniels' argument that we failed to establish prima facie trespass is just not correct. That's the point that I was trying to make, Your Honor. So Section 5A2 is like an ingress-egress rights for utility lines. So for example, the city's water main is on the other side of your neighbor's property. The utility easement gives you the right to run a pipe across your neighbor's property to bring the water from the city main to the building, right? The conventional easement is the right to travel across your neighbor's property without it being trespassed. The water pipe is like the car you use for the transit, but it doesn't give you the right to use the car, right? It doesn't give you the right to use your neighbor's gas in the car, in your neighbor's car. And likewise, Section 5A2 says that Rent2 can construct, install, and service utilities, but they have to install all of the utility lines. So if the fire suppression system, as Mr. Daniel says, takes the water from the main, and there is a pipe that's installed by Lot 2 from the Lot 2 building to the Naperville fire main, right? That goes from the water main that we connected into our building. And then that water, Mr. Daniel said, flows through our equipment and into their building. Well, they are required to install their own. It's a utility line at best. And they are required under the declaration to install their own. They can't share, they can't claim a right to it just because, and say because it's a shared system just by connecting to it. On the Michaels lease, it's, their resort to under easement law, in order to find a grant of easement, the granting document, again, because it's a statute of frauds issue, it has to be in writing in a document, and the granting document has to clearly evidence the intent to confer an easement. That clearly confer means that you can't look to extrinsic evidence. If you have to look to extrinsic evidence to find the grant, then that means that there is no grant. Now, I do understand that courts look to extrinsic evidence to interpret the scope of the grant, but you can't look to extrinsic evidence to find the grant, because that by in itself means that the granting document is ambiguous, and there's no.
Ms. Sim, thank you. Your time in rebuttal is up. And Mr. Daniel, you will have 5 minutes for a final rebuttal on your cross appeal. And starting first, I would ask, you don't have an easement, correct? Excuse me. You don't have an expressed written easement, correct?
We do.
Okay. And where do I find that?
You find that in exhibit number P13 and D11. This is the document that is attached as A165 in the appendix. So at A165, you see a zoomed in portion of the plat of planned unit development for the Waterside Center. 164 shows the cover page. A165
I
has,
have it now. So A165, and where am I looking at A165?
if you take a look at the top of A165, there's a rectangle below the words privately maintained.
Yes?
That rectangle is a sign. It is connected from the north side of the rectangle, the upper side, via a line that runs through the letters UE for utility easement, and it turns south towards the building, and it takes a sharp turn in front of the building before it connects to the Lot 3 building. The language on that route says 1 4-inch PVC conduit for
So your
lot.
conduit goes from your lot 3 to the sign, and that is a picture of your easement, I guess. Is that what you're saying?
That is the granting instrument. That is a plat that was recorded by the owner, subdivider, and declarant before any sale of any lot. And the issue that we faced was that even though Judge Hayes denied summary judgment and in her order denying summary judgment in January of 24, she cites numerous cases that say easements don't have to carry particular language. You don't need to have granting language in every easement. The intent has to be apparent from the document. This is a plat. There are lines drawn to a particular location connecting the building to the sign, and it shows the sign on lot 2 with the note saying that line is PVC conduit for the lot 3 sign. Now, if you think about it, these documents are recorded in sequence. This plat is recorded before the plat of easements, one document number off. Following that, one document beyond the plat of easements is the declaration. The declaration itself approves the sign locations using the same rectangular feature and identifying them as signs. So we do have the granting document as a plat. And if you had to think about the resulting situation, if every plat had to have granting language in detail, take a look here for just below that. Parking for lot 3 is shown on lot 2. 23 spaces. Should we have granting language for that? This is a 15 to 17 acre shopping center.
So there was some reference to a document to be recorded later or not attached, something like that, I recall.
So if you take a look at, let's see here, it's A167 would show you the bottom of the planned unit development plat for Waterside Center. One of their arguments is that proposed future easements were never granted. They were only granted for certain things. If you compare the language for the parking and the language for the sign, there's no word proposed next to it. The proposed easements are to non-successors in title, people that will not own. These are public utility easements. And you can see that at A167 at the bottom, proposed PUNDE. That is a proposed public utility and drainage easement. And it says proposed. When were those carried forward? Those are public easements. When were those carried forward? The very next recorded instrument. The plat of easement is all public easements for people that are not owners within the subdivision claiming rights through the plat. And that is the distinction that I believe Judge Hayes missed and that ENS is trying to seize on in its brief. The court should not allow that because there are different instruments for different purposes. The earlier plat, P13, was between the owners of lots 1 and 2. The later plat, the grant of easements, was between lots 1, 2, and 3. It applied
Mr. Daniel, your time is up if you want to wrap up.
If I can, I just want to note that summary judgment denial was appropriate in this case. It merged. there are factual issues that Judge Hayes clearly identified. Under the circumstances, we are asking that you award attorney's fees. I think that is self-explanatory. You've heard a lot about fire suppression and life safety. Thank you for your time.
Thank you. Questions from the panel?
Yes, I had a question for Ms. M from her rebuttal. With regard to, could you address Mr. Ritter's testimony with regard to the fire safety and the location issues that were raised?
I think that that what he testified to is that having the two meters, the electric panel meters, because it has shut off next to each other, that it's nice to have them be close together so that you can do that, but it's not it's not something that would require you to put them close together. For example,
Saying that it's nice to have them available to all the tenants in the event of a fire so that you don't have to go into the other property to shut off something that's impacting your property?
Justice Davenport, if I may. So the ENS, the lot 2, the ENS property has 2 transformers. One is for the Michaels section of the building, and they have their own transformer. And that transformer is actually around the corner on the other side of the building, with the meters around the other side of the building. So even when you have 2 adjoining sections of a building on a single property, it's not such an important consideration to have the 2 meters close together. They could, if it was an important consideration, they would have put the 2 transformers next to each other. They were building from a vacant lot.
Okay, thank you. One other question that I had was, your position is that ENS maintained its obligations to maintained its improvements, correct? It met its obligation to maintain its improvements.
Yes, Your Honor. I'm not
Do
sure
you
what
think do you think the removal of the fire safety is classified as maintaining its improvements? How is the removal maintaining?
Because our fire suppression system was not impacted. We had when it was disconnected, the fire department came and they inspected the fire suppression system, and our building was completely protected. So
Okay,
our
thank you.
lot was
Okay,
protected.
all right. Thank you. Thank you, Justice
Justice
Hedl.
Anderson, any questions?
Thank you.
Mr. Daniel, I have just one question or clarification. So you would acknowledge that whatever electricity that your fire suppression system and whatever water that your fire suppression system used, either for tests or if it was ever enacted, would be something that Ms. M was paying for, or her client was paying for, I should say.
Her client, the facts show that her client was paying for it. There's no proof of what they were paying for it. But there's somebody getting billed. It's not as if we're taking a resource from them. So it's not a profit, which is one of the arguments that was addressed below, a profit of Pendray.
Okay. Thank you. There being no further questions, I appreciate the spirited arguments. Very interesting topic, and thank you very much, counsel. We will take this under advisement and issue a written decision in due course.
Thank you, everyone. Thank you.